Business lobby group Sakeliga and the National Employers Association of South Africa say they will appeal directly to the Constitutional Court to try and stop the government from implementing employment equity targets in South Africa. This follows a loss in the Pretoria High Court, where the urgent bid to interdict the implementation of the policy from the 1st of September 2025 was dismissed. For more, we are joined by Piet, who's the CEO of Sakeliga. Piet, thank you so much for your time this evening. Now, you claim that the regulations in the Employment Equity Amendment Act have impossible requirements. You've called it harmful. Why are you fighting against these regulations that are built for transformation?
The reason has been the same all along. The regulations are impossible to implement. They require businesses to be run off a spreadsheet. It's done nowhere like this anywhere in the world. It requires every business anywhere in South Africa to subscribe to race and sex and disability targets prescribed by the minister at a arbitrary way that she decided that. That is not how business is done, and we must respect the independence of a business. So also because it's impossible, also because it is harmful and it will actually lead to a decrease in employment, this is something that must be opposed.
How is it harmful? You are aware of South Africa's history stemming before apartheid that created systemic discrimination based on race and gender, yet you refer to these transformation laws as unjustified state intervention. How is that unjustified unless you aren't aware of the history of this country?
By that logic, anything the minister does, as long as she refers to the word transformation, can be justified. And that is not the burden of proof. The minister needs to explain why it is justified. And in fact, as I said earlier, it is impossible to meet these targets.
How is it impossible, Mr. Roux, to meet targets that are built and there and formed for equality of races that have been discriminated against for over decades and hundreds of years? How is it impossible?
Well, let me ask you, how is it possible for the transport sector to cause 50% of drivers to be female? There's about something like 1 or 2% right now, and the targets require that 50% of truck drivers become female. How is that justified? Is that not obviously disrespectful to the people who are currently employed and the preferences of women and the nature of society?
Let's speak about disrespectful, because those sectors that were identified by the minister that you were trying to halt these employment equity regulations for as a wide range of sectors, from accommodation to food services, construction, agriculture, mining, real estate, retail, arts and entertainment, and the list goes on and on and on. It's almost every single sector that you are saying that will be harmed if there is transformation.
No, that's not what we said. Don't lay words in my mouth. I'm saying that the implementation of the targets by the minister will be harmful. And we did have a concrete example, and you said that it's obviously not harmful, but I just pointed out to you that it is obviously an unattainable, just one example. These targets are run off a spreadsheet. There are hundreds, if not thousands, of iterations possible. Even if the company doesn't matter whether it's in Messina or in Port Elizabeth or in Springbok or in Durban, as if everyone everywhere should subscribe to the minister's targets, disregards the nature of family businesses, the different preferences of women, of men, the different makeup of communities all across the country. We can't run a society off a spreadsheet like this. I know that the minister says it's in the name of transformation, but just because the minister says so does not make it acceptable or not harmful. And I've already pointed to you out just one extreme example of what is obviously unattainable. And therefore, you know, if the trucking companies don't do, for example, what I've told you now, they're liable for up to 10% of turnover as a penalty. And if they keep not doing it, their executives are liable for jail time. Now, just all of that because the word transformation was invoked doesn't make it acceptable.
It's not just a word, sir. It is also about a history. So how do you propose that hundreds of years of discriminatory laws that have created an unequal society be rectified economically?
I've answered a couple of questions, but you've skipped mine. I've given you a good example of what is obviously unattainable in one sector But you just keep throwing back such a broad question at me.
Because
Isn't
it is
there
a
an
broad,
obvious
it is
problem?
broad sectors that you are halting this for. I mean, for arts and entertainment, how does transformation hinder and harm businesses? That arts and entertainment, hospitality, accommodation, mining, manufacturing, you saying let's leave all these industries untouched and leave what has happened in history and not create some sort of transformation. So I'm asking you, sir, how do you propose that we change the status quo that was created over hundreds of years?
Where did I say that all these businesses should be left untouched? Could you
These are
just
the
refer
ones
me
that
to...
the minister identified. These are the factors, these are the sectors that have been identified by the minister in the government gazette that you are now also saying you take into the Constitutional Court. But I'd really just like a blanket answer in terms of how you propose transformation happens.
No, that's not. You asked me why we're appealing, and we're appealing because the quotas by the minister is harmful, because it is unconstitutional, and because it is impossible to attain, and therefore it is an unjust requirement. And I've given you some examples, and it's important to recognize that I've given you concrete examples that you now ignore, but these are obviously problematic. And I know that you're trying to frame a lot of this around race, and a lot of it is around race.
It
I mean,
is.
I think it's... Yes, I know. But I think it's also unacceptable to have quotas that put a hard cap, a limit on 4% of white males in up to 25% of sectors. And I'm not saying that businesses shouldn't have no white males even, but I'm saying that it's unacceptable for the minister to lay down targets and quotas, and if it's not attained, then by up to 10% of penalty, and to ignore the realities of the country, the skills composition, different preferences of communities. And I've given you concrete examples of how this is unattainable. So the word transformation does not appear even in our press release, which you are requiring or talking about now. We are, as Sakeliga and Neasa, making an appeal to the Constitutional Court, because we think that what the minister is proposing is outside of her powers, that the act is actually unconstitutional, and that if it is allowed to stand, it will be very harmful, including to the communities, the black communities, the colored communities, the Indian communities, and the white communities. It will be harmful to men and to women. It will be harmful to people who are disabled, wherever they are overrepresented in a company. Remember, the axe will fall on them, and that company will be harmed. The employment prospects of all the other groups in that company will be harmed, and the goods and services available to its customers will be harmed. So this is really a public interest matter, and I know that some people find it acceptable that in the name of transformation, what seems to be limiting white people's ability to participate in the economy is acceptable. If that's okay to you, I don't think that's good, but that may be so. But the harms are not limited to the intention of the minister.
Different. Sorry, we have run out of time there. That's all we have time for. We